I'd like to welcome everybody to today's Health Law and Ethics Network seminar for November. My name is Paula O'Brien. I'm an Associate Professor at Melbourne Law School and I'm one of the directors of the Health Law and Ethics Network. To start the seminar, I'd like to pay my respects to the Indigenous owners of the lands on which we are each seated, and pay my respects to their elders past, present and emerging, and particularly pay my respects to any Indigenous people on the call today. We're really pleased to hold this seminar today, and the title for the seminar is Medicinal Cannabis and Driving, the Intersection of Health and Road Safety Policy. And the seminar today is presented by Mr Hugh Brophy from the Department of Health, and the seminar today incorporates work that is part of a published paper that was led by Hugh and Daniel Perkins, who was then also in the Department of Health. I was one of the co-authors on the paper. There was a large team. It was an interdisciplinary paper and it drew together people with different expertise around medicinal cannabis. So the seminar today will draw on some of the work in the paper. We're really pleased to have Hugh with us today. So we really appreciate you doing the paper today, Hugh. Hugh's a Senior Policy Officer in the Victorian Department of Health. And during his time at the department, he has worked on a number of major reforms in the area of health, including Victoria's Voluntary Assisted Dying Act and the Medical Treatment Planning and Decisions Act. And more recently, Hugh has been working to facilitate access to medicinal cannabis for Victorian patients under both the state and Commonwealth drugs and poisons legislation. And in this role, he's been involved in several projects that have been evaluating the safety and potential therapeutic application of medicinal cannabis products, as well as their effect on driving and cognitive function. So Hugh is going to present for about 30 minutes and then we'll have a chance for more questions and discussion about the topic. So thank you very much, Hugh. We really look forward to the paper today.
Thank you for the introduction, Paula, and thank you also for having me here today to present. So I thought I'd begin with just a quick little overview of medicinal cannabis and its place in Australia. So I'm sure everyone's noticed that the last decade has seen global attitudes towards cannabis shift quite dramatically, in part because its therapeutic potential has become better understood. So there's over 50 countries now that have established some sort of legal access pathway to allow patients to use medicinal cannabis for the treatment of a wide range of medical conditions. In Australia, the introduction of legal medicinal cannabis began in 2016 when Victoria became the first Australian jurisdiction to legalise access. Quite soon after that, a few other states began to draft legislation to do the same, but rather than have every jurisdiction go off and develop their own approach, the Commonwealth very sensibly stepped in early 2017 and introduced a national regulatory framework covering cultivation, manufacture and also patient access. They did this by amending the Narcotic Drugs Act and the Poison Standard. So that effectively just grandfathered in medicinal cannabis products into existing drugs and poisons regulation. Unlike some other countries such as the US and Canada, which have dispensary models which are separate from usual prescription processes, the framework applied to medicinal cannabis in Australia is much the same as it is for all other therapeutic goods. So products have to meet pharmaceutical standards and can only be accessed via a prescription from a doctor. There's a bit of nuance that makes medicinal cannabis unique at the moment, as the Commonwealth TGA are having to approve access to most prescriptions. I won't go into too much detail around the prescription process because it's going a bit into the weeds, but if anyone has any questions about it, I'm happy to talk to it at the end of the presentation. The important takeaway for now, though, is that unlike illicit cannabis sourced from the black market, all legal medicinal cannabis products in Australia are standardised pharmaceutical grade medicines that you can only access via a prescription from your doctor for the treatment of a diagnosed medical condition. Products do vary based on their composition, so what cannabinoids are in them. Primarily, they vary based on the amount of THC, which is the psychoactive ingredient in cannabis, and it has the intoxicating effect. And the other main cannabinoid is cannabidiol, or CBD, which people may have heard of, which is non-intoxicating. But most products prescribed in Australia have at least some level of THC, so about 4/5 of products prescribed do. They'll also vary in terms of how they're administered. So the vast majority of prescriptions at the moment are for oral solutions, so oils, sprays, things like that. When medicinal cannabis was first legalized, very few patients were accessing these products. So over the first couple of years, there were only around 20,000 prescriptions issued. And then in 2020, there were about 60,000. And in 2021, we've had close to 100,000. When you compare it to something like opioids, which have over 15 million prescriptions dispensed a year, it's still a very small number of patients accessing these products, but it is growing. And as prescriptions have continued to grow, it's starting to produce some tensions with other regulatory frameworks, which have existed since before people could legally access cannabis. And one of the most notable ones here in Australia are our zero tolerance drug driving laws, which at the moment don't differentiate or distinguish between illegal recreational cannabis abuse and the legitimate and legal use of a medicine. So how do we regulate drug driving in Australia? Well, each Australian state and territory has its own drug driving legislation. They usually are called something like the Road Safety Act or Road Transport Act. And these different pieces of legislation contain offences specifying a group of illicit substances that it's illegal to have in your system while driving. We loosely refer to these offences as presence-based offences, and because any detectable amount in a driver's bodily fluid constitutes an offence, Australian jurisdictions have been described as having a zero tolerance approach to drug driving. Now, enforcement of presence offences is done primarily through roadside oral fluid tests, which are conducted by police through mass screening programs. In Victoria, there are around 200,000 tests conducted annually. The exception to this is Tasmania, where they don't test oral fluid at the moment. Blood samples are instead taken if a person is suspected of drug driving. But with the exception of Tasmania, the process generally follows that police will take a saliva sample for initial testing at the roadside in the drug bus. And then if a positive result is found, it's sent to the lab for confirmatory testing. And this is to rule out the risk of false positives and things like that. Overwhelmingly, we only police presence offences using roadside fluid tests, or oral fluid tests, sorry. But we can also enforce presence tests through mandatory blood tests, which are administered to drivers if they're admitted to a hospital following a road accident. And the drugs we test for vary slightly across jurisdictions in Australia, but there is consistency across all states and territories that it's illegal everywhere to drive with the presence of MDMA, methamphetamine, and THC in your system. The rationale behind testing for these substances is that excluding alcohol, they're the most prevalent impairing substances found in a driver's blood after fatal roadside accidents. So methamphetamine is by far the most common, and then THC is roughly equal to alcohol. New South Wales have recently started testing for cocaine at the roadside as well in oral fluid. And New South Wales and the Northern Territory and also Tasmania, they also have presence offences for a few other drugs which they'll look for in blood if it's taken following an accident. Notably, in these jurisdictions which test for some additional substances in blood, there exists a medical defence for having the presence of a drug which could also be a medicine if it's been prescribed by a doctor. So in New South Wales, the medical defence covers having the presence of morphine in your blood, and in Northern Territory, it covers morphine, methadone, and amphetamine. In Tasmania, the medical defence covers any drug if it was prescribed and taken as directed by a doctor. And because of how broadly their legislation is written and this defence is written, it should cover prescribed THC, although this hasn't been tested in court yet, to my knowledge. Importantly, the medical defences only provide an exemption to presence. So if the person is impaired, they could still be charged with driving under the influence or driving while impaired offences, which also exist in Australian states and territories. And I'll talk a bit more about those in a moment. But to quickly summarise, every state and territory, with the exception of Tasmania, enforce presence-based drug driving offences by testing oral fluid. While there are medical defences in some jurisdictions for having a prescribed drug like morphine present in your blood after an accident, there hasn't been a need to introduce a similar exemption for failing a roadside oral fluid test, as these tests have historically only targeted substances which are prohibited, so methamphetamine, MDMA, and until recently, THC. But illicit drugs aren't the only substances that can impair driving ability. There are a lot of commonly prescribed drugs that can also increase your risk of being involved in a traffic accident. Research investigating these risks, or the risks associated with prescription drugs, is much less well developed than for illicit substances. But this slide provides a bit of an overview of different classes of impairing drugs and their associated crash risk, just based on the available systematic and meta reviews that we have. As a point of comparison, a BAC of 0.05 has a crash risk odds ratio of around 1.8. So we can see that while the risks associated with impairing medicines is lower than this, there is still a risk present, and it can be quite significant for some drugs like benzodiazepines and opiates. So how do we manage these risks associated with impairing prescription drugs? Well, medicines that have possible sedating effects or can cause drowsiness are required to advise patients in their product information booklets not to drive or operate heavy machinery if experiencing such effects, and also to avoid alcohol. They also need to have the label I have up on this slide clearly present on any packaging. Importantly, medicinal cannabis products that contain THC need to have all these warnings and labels as well. Prescribing doctors and dispensing pharmacists are also required to warn patients to monitor the effects of these drugs and refrain from driving if impaired. And then in addition to labelling and warnings, most Australian jurisdictions also have offences relating to driving under the influence, so DUI, or driving while impaired. The way these offences are usually written is that a person needs to be incapable of having proper control of a vehicle due to the influence of a drug. So any drug, licit or illicit, it doesn't specify. These offences typically require noticeable signs of impairment for a charge to be laid by police, and usually the method of determining this is a roadside sobriety test, which people are probably familiar with from American TV shows like Cops, where the police will get the driver to perform a battery of tasks like walking in a straight line and things like that. A sample of blood or urine is usually also obtained, as additional supportive evidence is generally required in order to prove a DUI or DWI charge in court. And then finally, the last way we manage driving risks associated with prescription drugs is through fitness to drive assessments. So some individuals with certain health conditions can be referred for these fitness to drive assessments. And in some jurisdictions, these can be mandatory for certain health conditions. So in South Australia and Northern Territory, you have epilepsy, you need to undergo a fitness to drive assessment. Health professionals who undertake these assessments need to consider both a patient's condition and then also the treatments they're receiving. And then in relation to prescription drugs, they need to try to find a balance between any potential impairment the drug may cause with any improvements in health the patient may experience, and how those together will affect their ability to safely drive. So there's a clear distinction in how we regulate illicit and prescription drugs in terms of road safety. For illicit drugs, criminal offences are applied based on presence alone, while for prescription drugs, warnings and advice help patients regulate their own behaviour, and then DUI, DWI offences are also available to police, but require evidence of actual impairment. So getting back to medicinal cannabis, when it was first introduced in Victoria and then at a national level, there wasn't a whole heap of consideration given to how this change may interact with existing drug driving legislation, which, as I just discussed, makes it illegal to have the presence of THC in your system. The way we test for THC in Australia is not based on impairment. The offence relates specifically to presence. So for patients who have been prescribed a product containing THC, how are they to know how long THC is likely to be present in their bodily fluid? Well, we estimate that THC can be detected in your saliva for a period of up to around 78 hours after consumption. There's some anecdotal reports of it lasting much longer, up to a week, but this hasn't really been backed up by any studies or evidence. One thing that's worth noting, though, is that in terms of how long THC can be picked up in oral fluid, the 78-hour estimate is based almost exclusively on studies investigating smoked cannabis. And as I mentioned earlier, most products prescribed in Australia are oils and sprays. So it's been suggested that these products could actually accumulate in the mouth and be detected for much longer, but we really don't know, and we need to do more research into this. In blood, THC is highly lipophilic. I hope I've said that right. What that means is it accumulates in the body fat and soft tissue of people who regularly use it, and then it gets slowly released over time. So for this reason, THC can be detected in blood for up to and over 6 days, particularly in regular users like patients. So as a result of all this variability, it's nearly impossible for medical practitioners or law enforcement agencies in Australia to provide accurate information to patients about how long THC is going to be detectable in their system. And so current advice across the board is that patients should just not drive at all if they're prescribed these products and wish to avoid the risk of being charged with a presence offence. So for patients who are legally accessing medicinal cannabis in Australia, our zero tolerance drug driving laws are making it so they have to choose between limiting their mobility or risking criminal charges. Obviously, not being able to drive makes it harder for these people to access goods and services, including healthcare, and to just generally participate in society and everyday life. This exclusion is compounded in rural and regional areas where people don't have access to public transport. And then for patients who do choose to drive, they face the very real possibility of conviction under a presence offence and the associated penalties, including fines, licence suspensions, and possible imprisonment. Also, if they're in an accident and THC is detected in their blood, even if the accident was caused through no fault of their own, they may incur financial penalties if claiming compensation through their accident insurance provider. So in Victoria, that's the TAC. It's unsurprising that because of how drug driving laws are being applied to medicinal cannabis, that many patients are also deciding not to fill their prescriptions or to discontinue treatment, and may instead swap to other potentially more harmful and impairing treatments. Now, our department receives quite a bit of correspondence regarding this issue, and I thought I'd share with you one such example we received from a 62-year-old cancer patient. I have tidied it up a bit to get it onto the slide, but it reads, "After exhausting all conventional treatments, I received medicinal cannabis as part of a clinical trial and found the results to be favourable. I wanted to continue via prescription from my GP. However, the police informed me that even though it was medically prescribed, I would be fined and have to go to court should I ever take a roadside drug test. I decided not to continue as I didn't want to give up driving, which is crucial for me to be able to live an independent life. Because of this, I'm continuing to use MS-Contin, which is an opioid, and Lyrica, which I don't like and would much rather be taking medicinal cannabis to deal with the discomfort." Now, I certainly don't want to underplay the very real risks that are associated with THC consumption and driving. Experimental studies such as those using driving simulators have very clearly shown that THC has effects that can impair driving ability. It can impede your coordination, visual function and attention, and these effects can persist for several hours after consumption. Epidemiological studies looking at population level data, so number of accidents and things like that, have been a little less or much less consistent in identifying what exactly the road safety risks are in relation to cannabis use. The most recent meta-analyses we have estimate that the odds ratio of being involved in a crash with THC in your system is about 1.4, which is quite significant, but it is, again, notably lower than the crash risk we associate with the legal BAC limit of 0.05, which is 1.8. On the subject of alcohol, it is also well established that the impairing effects of THC increase significantly when combined with alcohol. So people using both substances at the same time have a much greater risk of being involved in an accident than those using one or the other. I think it's important also to introduce a bit of a caveat when talking about all of the associated risks with THC and driving, is that pretty much everything we know and understand about these risks is based on research investigating recreational cannabis use. Research specifically looking into medicinal cannabis products containing THC and road safety risk is extremely limited at the moment. So in the absence of this research, it makes sense that policymakers are having to assume that the impairing effects of recreational THC can be applied to inform how we manage medicinal cannabis and road safety. But there are probably a few reasons why it may not be appropriate to assume that the risks associated with medicinal use are the same as those attached to recreational use. Firstly, we understand that recreational users of cannabis are taking the drug to achieve a psychoactive effect or a high. In contrast, the goal of any medical treatment is to achieve clinical benefit while avoiding or trying to avoid unwanted impairing effects, with patients starting with a low dose and then titrating upward to achieve the intended result under the supervision of their doctor. Recreational users of cannabis are also overwhelmingly young adult males, which is a subpopulation holding high-risk attitudes towards driving, and this group is overwhelmingly represented in crash statistics. In contrast, most medicinal cannabis patients are over the age of 50 and are predominantly female. In addition to demographic differences, the people using medicinal cannabis are patients who are taking a medication to treat a diagnosed condition. We expect for other prescription drugs that improvements in clinical symptoms following treatment may offset any detrimental cognitive or other impairing effects, either directly or indirectly. And this very well could be the case for THC as well. In fact, one of the only experimental studies that's been done looking into the issue of medicinal cannabis and driving found that after they achieved a stable dose with an approved cannabis product called Sativex, which is available here in Australia, containing 50% THC, 50% CBD per mil, patients with MS showed no evidence of increased accident risk, and in some cases actually showed reduced risk. It was a small study though, so difficult to draw any firm conclusions. It was also on a very specific patient cohort, but still, it's interesting. Australia, of course, isn't the only jurisdiction that's legalised access to medicinal cannabis, and there may well be lessons we can learn from looking abroad to see how other countries manage to balance patient access and associated road safety risks. Countries like the US and Canada make for a pretty poor comparison with Australia, though, as I mentioned, they have those more permissive dispensary models of access, but they've also largely legalised access to recreational cannabis, so their policy response in terms of road safety reflects that. We were able to identify several jurisdictions internationally which have introduced similar medical-only access models to Australia. So that's where pharmaceutical grade products are available only via prescription from a doctor. These jurisdictions include Norway, Ireland, the United Kingdom, Germany, and New Zealand. When we were looking into this, all of these countries except New Zealand had drug driving presence offences relating to THC, similar to those that exist in Australia. But New Zealand was in the process of introducing similar offences. I'm not sure if they actually have yet. It was scheduled for 2021, so they could be very close to introducing similar roadside fluid tests that we conduct in Australia. There is some variation in how presence offences are enforced. Norway, for example, only tests blood. However, in every case, all of these countries have adopted some form of medical defence for presence offences, which allow patients to drive if they're using a prescribed product as directed by their doctor and they don't show any other signs of impairment. So in practical terms, how this works is when a driver is stopped at a random roadside checkpoint, who tests positive to THC, but doesn't otherwise demonstrate any impairment, so slurred speech, dilated pupils, lane weaving, things like that, they're not subject to a drug driving offence if they can provide proof of prescription or some other sort of medical certificate. In New Zealand and Norway, where oral fluid isn't tested, just blood is, the medical defence applies to various other prescription medicines that these jurisdictions test for, such as morphine, benzodiazepines, and so on. These countries have been testing for prescription drugs prior to medicinal cannabis being legalised, so it was very easy for them to just extend the medical defence to THC when it was introduced as a prescription drug. Ireland is a bit of an interesting case, as similar to Australia, before they legalised access to medicinal cannabis, they were only testing for the presence of a few illicit substances, so meth, amphetamine, MDMA, THC, in oral fluid. But when legal medicinal cannabis was introduced, they also introduced a medical defence for patients that have been prescribed these products. I should note, though, that in Ireland, you can only access medicinal cannabis to treat MS and epilepsy, so it is a much smaller group of patients accessing these products than here in Australia. But when we compare Australia to these companies, it does appear as though Australian jurisdictions, except Tasmania, are a bit of an outlier, in that no state or territory has a medical defence for having the presence of THC in your system if it's been prescribed. So as the number of patients accessing medicinal cannabis continues to increase in Australia, achieving the appropriate balance between road safety and patient access objectives is likely to gain further attention. Currently, medicinal cannabis is being treated more harshly under existing drug driving laws than a number of illicit substances, which we simply don't test for. So as I mentioned, New South Wales is the only jurisdiction that currently tests for cocaine. Current laws also accept risks associated with the use of alcohol up to a BAC of 0.05, and alcohol is used recreationally. It's not prescribed by a doctor to treat an illness. So taking this into account and noting that many international jurisdictions have found a compromise in the form of a medical defence for legitimate patients, It may be that continuing to apply zero tolerance drug driving laws to patients who are using a legally prescribed medicine could be untenable in the longer term. But exempting patients who are prescribed these products does carry legitimate risks to road safety. THC is an impairing substance, and as with other drugs of dependence, such as opioids and benzodiazepines, there's a real risk of abuse and misuse. There's also a risk that patients may substitute prescribed products with cheaper illicit cannabis bought from the black market. Cannabis is the most commonly used recreational drug in Australia after alcohol, so this risk is heightened when compared to other prescription drugs. But there are some additional policy options that government may consider alongside a medical defence to address the heightened risk associated with THC. And these could include requiring a zero blood alcohol limit for medicinal cannabis patients due to the known cross-impairment caused by THC and alcohol. We could prohibit patients from driving during the first few weeks of treatment, and this is done in Norway to allow for dose finding and tolerance development. And then we could also specify maximum daily amounts of THC, beyond which patients would no longer qualify for the medical defence. And this is applied in Israel currently. And finally, we could just improve patient education and advice around the impairing effects of THC and how long those last, which would assist them to manage those risks. Other jurisdictions, including Canada and Norway, have set what's known as a per se limit for THC. So that's where a specific amount of THC per mil in blood is thought to correlate with impairment. So similar to what we do for alcohol and a BAC of 0.05. It's been suggested that setting a per se limit for THC in blood for patients could allow them conditional access to driving while mitigating road safety risks. But in my opinion, I think due to the nature of THC metabolism and elimination, a lack of clear correlation between blood levels and impairment in high frequency users like patients, and still the inability to provide accurate advice to patients regarding how long THC will be in their bloodstream for, the use of per se limits in Australia is near unworkable. Even in Norway, for example, where they have an upper blood threshold of THC of about 9 nanograms per milliliter or mil, I think, has been adopted for the general population, but there's still an exemption from this limit if the THC is being prescribed by a doctor, which reflects that regular users will likely have around this much in their blood at all times, even if they're not impaired. Ongoing improvements in roadside impairment detection also offer a pathway forward. So the potential application of new technologies such as apps and artificial intelligence. This will be important for improving the enforcement of DUI, DWI offences more broadly, because at the moment they're quite underutilised compared to the presence offences we have. And that's relevant for all potentially impairing medications and drugs, not just medicinal cannabis. So before I wrap up, I thought I'd just provide a bit of an update on some recent developments that have been happening in Victoria in relation to this issue. Although there's still only a small number of patients accessing these products, both Victoria and South Australia have already seen attempts by the crossbench to introduce a medical defence for medicinal cannabis patients that test positive in a roadside drug test. In Victoria, Fiona Patten from the Reason Party introduced a road safety amendment bill at the end of 2019, which would have amended our Road Safety Act here to provide a medical defence for medicinal cannabis if it's prescribed and the person isn't otherwise impaired. Debate on the bill was delayed due to the pandemic until the end of 2020. And while the government didn't end up supporting the motion, they did agree to establish a working group to investigate setting out some sort of pathway forward to allow conditional access to driving for legitimate patients. The working group was comprised of state MPs, health experts, and representatives from various road safety agencies. And unfortunately, they weren't able to reach a consensus on how to allow conditional access to driving for patients prescribed medicinal cannabis. The working group concluded that in the absence of available research related to medicinal cannabis and driving specifically, research into the impairing effects of recreational THC would have to be used to inform an appropriate policy response. And it recommended that more research will be required before any change to the current policy settings could be considered, and that for now, presence-based offences should continue to be applied to patients who have legally accessed medicinal cannabis. So off the back of that, the Victorian government has committed to fund a couple of studies looking specifically into medicinal cannabis and driving. On their own, they're probably not going to provide a clear pathway forward to resolve the issue, but they are a step in the right direction. So Monash University are going to help us develop an understanding of driving behaviours and patterns through a self-reporting survey of patients taking medicinal cannabis. And then Swinburne University are going to be doing 2 studies. One is to determine the effectiveness and sensitivity of the testing devices we use at the roadside to see if they pick up a number of different commonly prescribed medicinal cannabis products. And they're also going to be doing a driving simulator study where patients suffering from chronic pain who have been prescribed medicinal cannabis are going to come in prior to treatment and undergo a range of driving tasks and cognitive tasks. And then they're going to come in over the course of 4 months of treatment and we'll measure their driving performance over this period. So that brings me to the end of my presentation. I think we're going to hand back over to Paula to facilitate some questions. I might stop sharing my screen as well if I can figure out how.
Okay, well, thank you very much. Thanks. That was such a great paper, and it really, I thought, presented the issue so well, giving us such a good overview of the issues that are raised. So Michelle's already got her hand up, so why don't we go straight to Michelle with a question. Thanks, Michelle.
Thanks, Paula, and thanks, Hugh. Can you hear me? Yeah, good. Yeah, that was really interesting. I learned a lot of things. I wasn't sort of sure about, firstly, about the THC content in medicinal cannabis, because I'd understood that there wasn't, so they'd sort of separated that out. So I guess I had 2 questions. One was in relation to that, but my first one was this idea of what impairs driving. And I assume that Monash study is that sort of what that's partly looking at, how you sort of assess what impairs driving. But I think that's such a difficult thing to, I guess, grasp. And there's because also there's so many other things. Like I sort of think about just driving in the car generally, like driving with small children in the back seat, eating and driving, like all those sort of. I'm not sure if there's, you know, studies into that, but those things are potentially more risky in terms of the, you know, that sort of statistic you were suggesting.
Yeah, absolutely. And there is a bunch of research going on at the moment looking into fatigue, which is thought to be as impairing and dangerous to drive as a lot of drugs. But a lot of time and research efforts have been put towards establishing the risks associated with illicit drugs over the past 30, 40 years. I mean, some have attributed that to the general, you know, war on drugs and as a way of deterring people from using drugs more broadly. But yeah, not a whole lot has been done into more commonplace sort of activities and prescription drugs that people take every day. Just because I think maybe as a society, we accept there are risks associated with those, and drug use, specifically illicit drug use, is seen as an illegal, dangerous activity that we should try to prevent. But going back to your original comment as well around the THC content of medicinal cannabis, it is a very common misconception that people have that there's no THC in medicinal cannabis. I'm not quite sure where that originates from, potentially a very clever marketing strategy from medicinal cannabis companies. But yeah, it's very hard to make a product that only has CBD. It's a very time-consuming and difficult manufacturing process, which results in quite significant costs for the final product. So most companies do have what's called full spectrum products, so they contain a range of cannabinoids, and invariably that includes some THC.
Just in relation to that, is the THC necessary for the effectiveness of the product itself, or?
It depends on the indication being treated. So evidence is still emerging in relation to most conditions, and medicinal cannabis is a treatment for those conditions. But CBD has shown some quite significant therapeutic potential as a treatment for epilepsy, but THC has not. THC is also sort of emerging as can be an effective treatment for cancer treatment related symptoms, so chemotherapy induced nausea and vomiting, things like that. But CBD has not been found to have any effect on that either. So yeah, there are specific indications that THC seems to be more effective at treating than CBD, and vice versa.
Thanks.
Thanks, Chris. Would you like to jump in?
Okay.
Yeah, thanks, Hugh. That was a really interesting talk. You guys have helped clarify my first question, I think, which is if you're just taking CBD oil that's prescribed, then you will test positive for THC. That's right?
No, so if you have managed to be prescribed a purified CBD product, so containing absolutely no THC or less than 2% THC, then it's very unlikely you'll test positive in a roadside drug testing screening, whatever. But also CBD we only test for THC. We don't look for CBD at the roadside or in the laboratory confirmatory test. So yeah, if you're prescribed CBD, you can drive, basically.
I don't know.
Okay. Well, I think that seems good. And a lot of the talk, it seemed like, I was going to put it a bit more strongly than you, that it seems like there's a natural injustice occurring here, that you can be prescribed something from your doctor, which doesn't, and you're not actually impaired at the time of driving because they're not testing for impairment, they're testing for the presence of a chemical. And that seems like, just seems like a natural injustice. And I was just wondering, you said there was it seems like the clearest way to get around that is the medical exemption, that if you're prescribed something by your doctor, that should give you a good case if you've been pulled over and you've been tested positive for THC. Do you know why the working group that you described at the end, looking at that, didn't just say, hey, here's a clear solution here?
I was privy to a couple of their deliberations. So the main concern was around substitution. So the concern that patients will go and get a prescription and then either not fill it or fill it and then continue to use illicit cannabis that they secured from the black market. And that is a real risk because medicinal cannabis is much more expensive than black market recreational sort of illicit cannabis. And they were concerned that, if the prescription process became very liberal in the future, that we'd have all these people who are, abusing cannabis recreationally with a medical exemption for presence offences. So that was the rationale. And as I also mentioned, that the idea that the recreational abuse of cannabis carries a certain risk was applied broadly to medicinal cannabis because there's a lack of research and most members didn't feel comfortable allowing a medical defence without more research into medicinal cannabis and driving specifically.
Like how it's
all right, thanks. Yeah, that's interesting. And just a final question, just back on that idea about the research that's being carried out now. It seems like there's lots of natural experiments now where actually recreational cannabis has been legalized in many parts of the world. And I know this is outside the scope of your talk, but do you know if there's any evidence that legalized recreation affects accidents levels and road safety?
Yeah, I there's quite a few epidemiological studies coming out of the US comparing states that have and haven't legalized recreational cannabis use. And it does appear as though it's quite clear that the number of people involved in traffic accidents that have THC present in their system increases after you legalise recreational cannabis, which is completely to be expected. But it also does appear as though the incidence of alcohol-related accidents goes down, and people involved in accidents with opioids and other things in their bloodstream goes down. But it's still quite relatively recent. Like the US have only sort of started the trend of legalizing over the past 5, 6, whatever years on a broad scale. So it remains to be seen, seems to be the general consensus from the research community.
All right, thanks, mate. That's great.
No worries.
Thanks, Hugh. And just to, before we go to Mark, so just a follow-up. So what is the cost of medicinal cannabis through one of the TGA special access schemes compared to somebody buying it, on the black market?
Yeah, look, it varies quite a bit depending on the product you're being prescribed and also the dose that's been prescribed. So higher doses obviously result in higher costs. So for some patient groups, such as children with epilepsy, which obviously aren't driving and they're taking CBD, but the cost can be upwards of $30,000 a year. And then for chronic pain, the general cost is around $50 per week for a medicinal cannabis product, but again, it can be higher. And then for illicit cannabis, I can't remember off the top of my head, but it's something like $13 to $20 per week. So it's about double at the moment. But we do expect costs to continue to fall as sort of supply chains and things work themselves out. They've already fallen by about 40% over the past year and a half. So it could be that the risk of supplementation becomes diminished over the time as cost becomes more affordable. But yeah, until there's some sort of subsidization for patients using large amounts, I would expect some supplementation to be continuing to go on.
And sorry, Mark, I don't mean to put you on hold, but just to go on the supplementation issue, because I gather that is a worry for policymakers. So do we have any evidence about how much supplementation is going on?
We have none at all, really. There's been previous studies looking into, how many people are using cannabis for both recreational and medicinal use. But the problem with these studies is they tend to attract, well, any self-reporting study tends to attract people with a vested interest in cannabis. So I think the last national survey that was done only 2% of respondents had actually been prescribed a product. And that was even though 20% of respondents said they were using cannabis medicinally. So a lot of people are still, self-medicating with illicit cannabis, but we have no idea in terms of the number of patients who are actually going out and getting a prescription and then continuing to use illicit cannabis. A part of me assumes it's not too much of an issue because the people have gone through the effort of getting the prescription, which is actually quite onerous compared to other medicines at the moment. But the cost would definitely be driving some people to supplement.
And basically the medical exemption can't differentiate between whether the product that's in the body is actually through the prescription or is actually through the black market. So
that's right. Yeah. THC is the chemical compound is the same regardless of where it comes from. So there's no way to differentiate at the roadside or in a lab if the product if THC is in the body because of a medicine or because of something like a joint was smoked or something like that.
Yeah, and that's different to other medicines potentially, isn't it?
Yes, it is. So for methamphetamine, for example, the legal amphetamines that can be prescribed, like dexamphetamine, they could set off the roadside drug test, but in a lab analysis, they'll have a different chemical structure. So they'll be able to, throw away the charge.
Yeah.
But THC, there's no point of difference.
Yeah. Thanks, Hugh.
Thanks, Paula. Thanks, Hugh, for that really interesting presentation. I think you make a persuasive case for legislative reform. What I was wondering, though, as I was listening to you, and I was wondering more as the conversation was going on up most recently, to what extent could the same end result be achieved through a policy change with regards to the testing strategy? Because a lot of the legislation you put up said, you've got a defence if there's no impairment and it was medically kind of prescribed. What if the testing strategy led the police only to test where there was independent indication that somebody was a road safety risk? So there was some kind of evidence of impairment that would be relevant when it came to prosecuted and the availability of a defence, even if we were to go down the legislative route. My understanding, correct me if I'm wrong on this, because this isn't my area at all, but my understanding is that insofar as there's a deterrent effect in relation to testing, there's a deterrent effect in relation to random testing for alcohol. So those kind of random stops, and when random stops going on in an area, that does have a tangible effect on drink driving. But I don't think random testing has much of a deterrent effect on drug driving, certainly not in relation to methamphetamine. I'm not sure about in relation to cannabis. But if random testing doesn't actually have much of a deterrent effect in relation to drug driving anyway, perhaps we should be targeting those that are otherwise presenting as a road safety risk. And if we were only testing them as a matter of policy, would we get to the same kind of end result?
Well, look, different agencies have different opinions on all this. You're absolutely right regarding deterrence, though. So breathalyzer tests we do for alcohol are administered in the millions in each jurisdiction per annum, whereas for drug testing, yeah, we've only recently started doing over 100,000 here in Victoria, when we're ramping up to 200,000. But there's no way that will have the same general deterrence effect across the population. And in fact, rather than being random, drug testing in most jurisdictions is actually quite targeted. So they're focused on high-risk settings, so after music festivals and things like that, or they're targeted at specific demographics, so young males and probationary drivers, and also people who have already been charged with a previous drug driving offence. And then in terms of testing for impairment, there's also a resource issue. So it's quite difficult for police to test for impairment. Those sobriety tests I mentioned during the presentation are very time consuming, and very few police officers are trained to do them. Whereas testing oral fluid at the roadside is a relatively straightforward process. And then also in terms of prosecuting, charging someone for a presence offence is much more straightforward than proving impairment in court. As I mentioned, generally, impairment requires things in addition to the sobriety tests to prove. So they'll need to collect blood or urine anyway, which is, again, a very time-consuming process involving either a nurse coming out to take blood or the police escorting the person to a hospital to do so. So from a resource perspective, police are very resistant to switching to an impairment-focused model. And then there are legitimate concerns that any deterrent effect that the random roadside testing is currently having could be undermined by focusing on impairment rather than presence, and that will result in an increased number of deaths on our road. So I hope that sort of responds to the question, but in terms of a policy change approach, I don't expect Australia will be shifting anytime soon. Australia is quite proud of their presence-based approach, and it does seem as though internationally the trend is to emulate Australia. So a lot of countries are moving towards presence-based offences rather than impairment-based ones.
Oh, that's interesting. Just in the table that you showed us, it seemed that majority of the current legislative schemes had impairment as one of the conditions.
So they're all testing for presence, but they have a medical defence for presence-based offences, not impairment-based offences. Impairment-based offences. So for the medicines, yes, there is sort of a more robust system that looks for impairment, but Australia has, compared to every other jurisdiction, the mass screening that goes on, even 200,000 is much, much more than any other country is undertaking. So there's definitely concerns that introducing a medical defence could undermine the mass screening program here in Australia.
Thank you.
Do we have any other questions for Hugh? Hugh, I was going to jump in and ask you about whether any patients have been prosecuted for under the presence offences.
Yeah, so not many. As I mentioned before, possibly because roadside drug testing is so targeted, and there's not a whole lot of patients that are attending raves or are on their Ps. So it hasn't really come up much. One of the first legal tests was in South Australia. A patient was charged for having THC present in their oral fluid. The magistrate dismissed the charge, though, on the basis that there wasn't any other impairment or signs of impairment present, though. But they did note that if the patient was charged again, then a conviction would be upheld. And then in New South Wales, another individual was charged and produced a prescription, but they also had illicit cannabis in the car with them. And I think the charge went through because it was unclear whether or not the patient had either taken their prescribed product or had used illicit cannabis.
So it's not, we don't think that there's that many prosecutions. Do you think the police are exercising discretion and choosing not to prosecute people, or people are just not being picked up, or?
So I can only really comment based on conversations I've had with representatives from Victoria Police. A police approaches and attitudes could vary in other jurisdictions, but The position of Victoria Police is that medicinal cannabis presents a road safety risk, and the Road Safety Act is quite clear that the presence of any amount of THC constitutes an offence, regardless of if it was prescribed or otherwise. And then from a process perspective, police don't have any formalised way of verifying if a prescription is real at the roadside either, because they've never had to previously. So I would say that in the event a patient is pulled over, it's extremely unlikely police would show any discretion about whether or not to charge them for having the presence of THC in their system. There could be some discretion applied to if after an accident THC was found in blood and the accident clearly wasn't the fault of the person who had THC in their blood, there could be some discretion applied there. But in Victoria, at least, the legislation is quite straightforward. So any discretion is more likely to come at the point of sentencing. And that was what we saw in that South Australian case I just mentioned as well.
Okay, thank you. Thank you very much. Okay, were there any other questions for Hugh? So my last comment was that, we've just seen the Commonwealth government, putting a lot of money through the MRFF into the study of psychedelics now for their potential to treat mental health conditions. So we saw, an explicit call for applications to study how these, so drugs, mushrooms, things like that could actually be used for therapeutic purposes. So what we're talking about here with medicinal cannabis, potentially is going to actually raise its head again with other types of illicit drugs that have these crossover use and become medicines and illicit drugs. So
potentially. I don't think it'll be as much of an issue, just at least at the moment, because of the way the TGA are likely to approve access to MDMA and psilocybin. So those products will only be able to be administered under doctor supervision, so hospital settings or inpatient settings.
Yeah.
And then in terms of how long they're present in a person's system for, MDMA clears quite quickly, and we don't test for psilocybin, but THC persists for quite some time. So I take the point that there's definitely crossover, but not the issues with drug driving and THC are quite unique, I would say. And MDMA and psilocybin, even if they are legalised, it'll be for a very small number of indications that probably won't have access to a vehicle for several hours afterwards anyway. So I don't think law enforcement agencies and road safety agencies will be as concerned with them as they are with THC.
Great, thank you. So any final questions or comments for Hugh? Great. Well, thank you very much, Hugh. That was really fascinating, and thanks for everybody for their contributions. It was a really interesting topic, and it's obviously just a space for us to watch, isn't it? About what's going to happen. This is research in train, and it's possible that on the basis of the research, maybe we'll see some change in the coming years. So, but thanks very much, Hugh. We're really appreciative of the presentation. So today's the last Health Law and Ethics Network seminar for the year. We are really grateful to all the presenters this year and to everybody for attending, and to Diane and Angela from the Law School for supporting the seminar series. We'll be back in February, and we wish everybody a really safe and restful remainder of the year, and we hope everybody has a great summer break and is able to start 2022 feeling refreshed about the year to come. So thanks everybody for joining us, and we'll see you soon.
Thanks, Paula.
Thanks, you.
Thanks, everyone.